Yes. Qualification criteria. The marks we obtained in the written examination, the test, physical measurements, and physical efficiency test, written examination. All these things are prescribed in terms of the rules framed under Article 309. Notification is nothing but reproducing the criteria prescribed under Article 303. Rules framed under Article 303. The petitioners have neither chosen to challenge the notification nor the rule.
What are the rules, Andy?
And moreover,
A rules name. What are those rules called?
rules framed under given as 87 and 97. A point of that one.
Name of the rules, just to write down.
I'm sorry. AP Police Stipendary Cadet Trainee Rules. 99 and amendments. At any rate, this is the notification issued in the month of November 2020. It is not open to them to legislate all these things at this very stage. That's an alternative. That second alternative in the first. That in absence of challenge to the notification as challenge to the rules, they cannot seek a differential treatment for home guards. Virtually, they are asking for differential treatment. Their submission is that having reserved certain percentage of proposed to them, the notification issuing authority ought to have relaxed mark criteria or physical efficiency test or written examination is the common substance of error. And to that level, my submission without challenging the qualification criteria, and all these things are notified in the notification. They are not chosen to challenge the notification. And are rules then under Article 309. In fact, notification is in pursuance of the rules framed under Article 309. That is stipendary training. And the second submission would be that all these contentions have been raised, and in fact, some of the contentions have given up in the earlier round of litigation regard to marks and other things. Authority considered all these things. and gave certain direction. That order has become final. Therefore, it is not open to them to re-educate arguments. Regarding first submission, may I invite your attention to exit page 133 document. Activate the P68. Page of that. Here is 315. That's what more that
గ్రౌండ్ ఏం చెప్పారండి? సెకండ్ గ్రౌండ్
marks are concerned during the course of arguments. They have given up. The prayer is also more or less 100. And page 133. Given is 315. Dated 3/10/99. Let me go over bottom of that page immediately after the notification meeting. The exercise of the powers conferred by the proviso to article 400. This is only to show that they are framed under article 309, and this GO may not be relevant. And next GO is an amendment to this GO. Is at page 142. At page 143. Two, three amendments, qualifications, top of that page. The qualifications, academic, age, and physical standards for various categories included in these rules shall be specified as in the annexure 1 appended to these rules. The upper age limits prescribed under also. All that cannot be necessary. And then you have to go over to subpara 3 minutes. Parity. Special categories, the various special categories and the eligibility criteria to be included in each of them are as and last para of that very same page. Home guards, the separate home guards.
Yes.
Persons who, as on the date of notification, have been on duty as home guards that may not be relevant. May not be relevant. And let's go over to the next page. Note pillar. That is awaiting note. The vacancies which remain unfilled in any of the above special categories for want of eligible category candidates shall be added to the vacancies to be filled by director. Rules itself more clarified that the special category vacancies, if they are unfilled, they have to be filled up with the general candidates. And insofar as qualifications, is physical eligibility test and all this. And those things are further amended through UMS number 87, dated 15/7/2016, which is at page 166. Right? This English amendment, it is clarified that it's only horizontal reservation. UMS number 87.
Yes.
And at page 167. Two, three, similar, bottom up, middle of that page. For rule 3C, the following shall be substituted, namely, classification.
Yes.
The rule of special representation provided in rule 22 of the other phase state and subordinate schools shall be applicable to all the classes and categories constituted in rules of code. The vacancies reserved for special categories referred to in rule 3D shall be adjusted in a horizontal manner on compartmental basis. The reservation of special category candidates shall be adjusted proportionally in the respective community category to which the candidate belongs. And here also it is classified that it is only horizontal reservation, special categories. And insofar as marks and other things are concerned, page 168. What are the minimum marks that are required to be page 168, just above the table. Preliminary written test, got it. Candidates shall be required to appear for the preliminary written test in 2 papers, which will be qualifying as given below the syllabus. And immediately after the table, note the minimum marks to be secured by the candidates in order to qualify in the preliminary written test in both the papers is 40% for OCs, 35% for BCs, 30% for SC, ST, etc. If a candidate fails to secure in one paper, he will still be disqualified. Total marks for these 2 papers will not be counted for the purpose of qualification. And physical measurements, subpara C. The candidate should meet the following requirements: height, chest, all those things are mentioned. And the physical efficiency test, page 169. Top of it mirror. Candidates declared qualified as above shall be required to undergo the following test and qualify as specified. Men and women candidates are qualified in so on so meters run, and 1 out of remaining 2 events shall be taken. The amendments made through UMS 87 dated 15/7/2016 talks about special category, talks about the marks to be obtained by the candidates. There is no having dealt with the special category candidates. The rules framed under Article 309 do not make any distinction insofar as special category candidates and general candidates are concerned, insofar as marks to be obtained or physical efficiency tests or physical measurement tests are concerned. Recruitment notification is nothing but reproduction of these rules. And they have not chosen to challenge the qualification criteria prescribed in the rules or in the notification. Also, with respect to the notification issued in the year 2022, they participated in the process and they have initially they appeared for the preliminary test, and thereafter the petitions came to be filed in the year 2023, raising various contentions. And including the contentions raised in the presented petition, may read the prayer in the earlier round of the petition. Is to issue an appropriate drink order or direction more particularly one in the nature of determinant of declaring the action of the respondents in disqualifying the petitioner, home guards for not securing the qualifying marks in the preliminary test on par with the direct recruit candidates by applying social or communal reservations right and in applying horizontal reservation to the special category of guards pursuant to the notification by the second respondent and in not extending the benefit of the judgment in WP number so and so and batch as illegal, arbitrary, unjust and contrary to the CD of the rules. In UMS number 315 and as amended by UMS number 97 dated 1/5/2006 and further direct the respondents to prepare a separate merit list among those. Pausing here for a moment, by the date of filing of these writ petitions, UMS number 87, which was issued in the year 2016, is in force. Page 166 document. They have not chosen to challenge, or they have not even referred in their prayer. They proceeded on the premise that the earlier views are in force. And they have neither challenged the notification criteria nor the rules. And be that as it may be, they raised this contention of relaxation of marks and given up such a contention, may straight away may invite your attention to the order pathway, my lord justice for a different. That's all from page 223. There are 8 minutes at page 228.
Page 250, para 37.
There are 8.
Para 37.
Before going to the 37, para 8, I want to refer to the contention. Para 37 is the home guards are to be treated as a special category and the minimum marks prescribed as per class 20 do not apply to that category. The second respondent should have prescribed separate cutoff marks for home guards, being a special category where itself no cutoff minimum marks are prescribed to the home guards in the road. That is the contention. And in so far as giving up is concerned, para 37 at page 2. The petitioners are not asking the second respondent to relax the marks. The petition being a special category in view of the orders of also. And we are going to prepare a separate example in the activity economic angles and thereafter apply compartmentalize the horizontal. That is finally, agreement having dealt with all these contentions, certain directions are given by Maramis authority. That order is being followed by the government. And with regard to that, they are now previous implementation of following orders. And only last portion of the order at page 253. The petitioners in the above petitions shall not claim any vested right because of interim directions granted pending in the petition. Those interim directions are granted enabling the petitioners to participate in the second level examination only. Of course, subject to preparation of a separate investigation. In this petition also, you are just supposes the prayer to the earlier round of petition. Earlier round of litigation, they have approved in this on report against disqualifying them in the preliminary test. Now, they have approached this on report against disqualifying them in physical efficiency test. Which that is very simple.
Yes.
Rest of it same. In this also, they are not even referred to U87. The notification is also not subject matter of challenge in the present. Qualification criteria and the marks required to be obtained by the home guard candidates is prescribed in the notification and the rules. And they have not chosen to challenge the notification and they participated in the process. And they have not challenged in the earlier round of litigation, notification or qualification criteria and as well as in the present notification. And at any rate, not having participated in the process, it is not open to them to challenge or to say that they should be given a differential treatment. And only cite on judgment 2021 12 SSC page 18. Engagement. 16. in the last 5 lines. And not coming to last by reading that. Therefore, once having participated in the recruitment process as per the advertisement, thereafter it is not open for him to contend that acquisition of higher qualification cannot be a disqualification and that too when he never challenged the eligibility criteria of the education qualification mentioned in the advertisement. Even otherwise, prescribing the eligibility even otherwise, prescribing the eligibility criteria, education qualification that a graduate shall not be eligible to apply was a conscious decision taken by the then, and the same was as per circular letter number. So on, so it is observed and held by this court that it is not for the court to consider the relevancy of qualification prescribed for various courts. But as has been pointed out to the rules prescribe all these things. Rules framed under Article 306. And notification is nothing but reproduction of those rules. Therefore, without challenging the rules, they cannot even challenge the notification. At any rate, there is no challenge either to the notification or to the rule.
Follow.
And the selection process is complete. They issued the appointment orders on 1/8/2025.
That is with regard to the regular cadre, but here they said that there are even the home guard, everything is filled up. 1167 posts are filled up. The last time I was told only 200 are qualified or something.
In terms of the rule, we cannot get candidates from home guards. I can fill up with the general candidates if the rule. I am not simply on the ground that they issue the appointment notification and all those. 22 notification, they having challenged and having obtained certain directions by virtue of minorities quality order. That order is being followed. Once again, it is not open to them in the year 2025, respecting a notification which was issued in the year 2020. Other petition is concerned where general candidates chosen to challenge the notification by filing an amendment application. That amendment application came to be filed in the month of July 2025. They seek to challenge the very notification through their amendment. All counter is required, but we find that they are not pertaining to home guards.
Is
Filed by Rajesh Kumar.
their age is an issue.
Yes. There, I believe the amendment is yet to be on. Their amendment.
I don't think so. I have not ordered anything.
Not ordered.
Not ordered.
Challenge the very note.
You can file your counter. It's only a formal.
This amendment application, well, I may have to. By Monday, I will be filing counter to put it to any other date. We can serve that counter by Monday.
Those are writ petition number.
Writ petition number 5904 6027 6025 and 4791. I have given gist of the case. I have mentioned that. Lordship may kindly see. Gist of the case I have given.
But the rules, of course, there should be challenge to the rules appears to be sound. But the fact that they have to be treated as a separate class was a judicially developed concept. It was not there at the time when the rules were framed. After 2008, 2011, and the division bench judgments said that they have to be treated as a separate class. What I was trying to say, this at the time, and it's okay, it's okay. At the time when the rules were formulated, they were treated as a homogeneous class. They were all falling under one group. So the parameters were same for everybody. Over a period of time, about 3 division bench judgments of this court said that they have to be treated as a separate class. And in fact, one of the judgments says that the inter se merit among them has to be taken into consideration for appointment. In fact, so how do we reconcile this situation when they have to be treated as a separate class? The rules mention the parameters for మీరు చెప్పింది కరెక్టే, రూల్స్ ఛాలెంజ్ చేయలేదు, correct. I'm not on that. But when they are to be treated as a separate class, how a general parameter is being made applicable? If you say technically rules are not under challenge, that is correct. I am not saying no to that. One is
Equal to this.
Yes, Amma.
188.
Actually, see the date of the judgment. 8/7/2016. Here is 87. 2015/7/20. The other judgment also is at page 192. Is to the notification issued in the year 2011 or 2011. From date,
Page number?
page 182. 192. Judgment is after the rules. Judgment dated 18 August 2017. Page 182 top will actually get it. But subject matter of the judgment is that are from 8 notification. That will actually get it at page 183. That page is 182 in the bottom. Correct. Yes, sir, that don't follow. When executing authority wants to give some preference to them, not at the cost of efficiency, subject to fulfilling all other criteria, a specific percentage is to be given.
Somewhere between general and ex-military, ex-service. Somewhere between, because the ex-military have around 9.5 minutes of 1600 meters they have to complete in 9.5 meters. The general have to complete in certain. But for all this, the technical issue of challenge to the rules is a issue that needs to be overcome. For all this to be passed or given, the rules, the physical parameters are specified. I'll just think. And,
Measurement as well as physical efficiency test, there is a reference. Once again, may
I'm just thinking. I was just thinking. I'm just wondering how to go about this.
So, having given some percentage, virtually it amounts to giving a go by to the percentage. It must be
No. What I'm looking at is once they are treated as a separate class, normally without reference to the general rules, there is a class, general class, where certain physical parameters are kept. They are not looking for relaxation of marks. Parameters are your criteria. Their submissions are that they are not going to come into the parameters that are going to be fixed by you. But what all they say is certain parameters should be fixed because we are an identified class. Because the very purpose of providing the post is because of certain historical reasons as to why they have been appointed. So when we have been 1167 posts have been fixed as a criteria, certain parameters should have been provided which are exclusive to 1167. In case we don't come there, we don't compete with the parameters fixed by you. They're not saying that you fix this as a parameter. If we don't come within 1167, then you can shift over to the general category. That's what they are saying.
the reason for which the recruiting agency has given any specific or relaxation to the parameters. But written examination and physical measurement test and physical efficiency test, Black knows very well that they cannot give a by having
I was only looking if it
regard to the duties that are to be performed by them.
Between general and ex-servicemen. We have provided some relief to ex-servicemen. Somewhere in between.
Not trying to denigrate they also rendered certain services. The only thing is it's in the wisdom of recruiting agency, it has prescribed certain quality. At any rate, they should have. Of course, that is the technical aspect.
That's the technical aspect. Let's think over it.
The more so at this belated stage, every process is completed. And in fact, another limited granted interim order in their favor, granting giving direction to the authority to allow them to participate in the final examination. And we preferred as we ability to set aside that order. And they preferred the SLP against that rejected.
That I didn't know.
That is the just before vacation, right? The interim order came to be passed, and we preferred that interim order ended up being which came up before me.
Is enough. It has enough to think over. Back our head. I can.
Everything is.
Chapter.
87. Your 87 is concerned, Milord. It is all subject subsequent to the noting in the earlier judgments. Principle laid down by the earlier judgment based on 97 GO. Now 87 GO is, Milord, only one thing, Milord. The Rule 22 is incorporated. We are not, Milord, earlier Milord, submitted. We are not at this stage, Milord, we are not disputing about the horizontal reservation. For that also, Milord, the earlier revision bench, Milord, and his lordship also said that when the home guards were recruitment is not based on the ROR, rule of reservation, and when the further appointment from among home guards category, if the rule of reservation is implemented, it is very difficult and it is a calculated risk of the respondents. That is what the word used, and the last occasion also I have read to your lordship at page para 8 to page 219.
But the physical parameters are fixed by statute under the rules.
Even that's why we are not canvass the 87 GO. That will come in the when merit list is prepared. Our contention is, Milord, we are declared as special category and we should have a separate parameters. That is the only request before your lordship.
But rules don't say anything like that.
Rules that Milord, rule need not be challenged. That is what the earlier findings.
Physical parameters are specified under the rules, and rules are not under challenge. One is class is identified, no doubt. They also recognize that class and provide you 1167 posts.
For that, your lordship kindly.
But
Page 154.
how is it that the action can be faulted in the absence of challenge to the physical parameters provided under the rules? It
Physical parameters.
logical consequence may be that they should have amended it in true sense, somewhere between general and ex-military, ex-serviceman. But at the same time, you should also challenge it. It cuts both ways.
Here, Milord, the qualification at page 154, marks, qualifying marks, nowhere about the home guards. We have already pointed out to your lordship. The same parameters was applied. Now, in the physical measurements are concerned, height and Milord, this thing, we are not seeking any. That was Milord accepted. We are seeking only the events. When we have participated in the events, we cannot be equated and the same parameters as per the general candidates. That is the only request.
I agree, but the rules should support you.
That the rule or notification need not be challenged. That was already fine.
No, I'm not saying so. But when rule says a post requires this physical parameter, how do we overcome that without there being challenged to that?
That's why the qualification is interlinked with Milord page 154 note. The same Milord parameters will made in the physical measurements also. That is our contention. Page 154 Milord.
We are now only with reference to events. Events are also specified under the rules.
Events as well as marks also, Milord. Prelims and mains. They have 40, 50, 30. That parameters cannot apply for us. That is our contention. That was already decided by the division benches of this honorable court, even earlier recruitments. If that is not accepted, the consequential measurements also this follows the same thing.
Why did you not challenge the rule? Simple. Digit iPad.
My reading of the earlier law, I thought that it is not necessary. There is clear finding to the effect. That was accepted by the division bench of this honorable court, Milord.
All right.
There are 216 Millard, page 216, discussions. Two one seven in the middle of the para, last 217 from first line onwards. I will read, Miller. However, a certain percentage of posts. Last got it. Page 217. Stop, Miller. However, the findings of the Honorable APAT Millard was confirmed by the division bench of this Honorable Court. That the reasoning given by the tribunal, Honorable Tribunal in OA was accepted in page number 217 of the division bench of this Honorable Court. The entirety of the findings given by the Honorable APAT was accepted. Page 217. I read one paragraph on that page. From top, in the middle it is there. Therefore, in the middle, therefore, the considering all the above, the tribunal came into conclusion that the home guards are treated as special guard. A direction was given to create a merit list based upon their performance in the examination without linking it to the specified marks prescribed to different communities and categories. This court agrees with the process of reasoning and also the conclusion reached by the Honorable Tribunal. Again, I read out to your Lordship the APAT order. In toto, accepted the decision made by the Honorable APAT. Therefore, for all purposes, not only physical measurements, for all purposes, selection process, we should be a different format. We are not asking to eliminate totally from the selection process, but We cannot be put up such a rigid selection process. If we ask Milat to completely eliminate us from the selection process and absorb us, we should have asked for regularization. '87 is not a concern, rule to only except that the other things are common. Only by '87, Rule 22, Rule of Reservation, horizontal reservation is incorporated in GO 97. For that, we are not objected, we are given up. That is the only thing, point we have given up. The other things, we are not. His lordship, the other litigation, his lordship said that the directions were given. None of them were not, there is no clear findings. In view of the orders passed by in the earlier batch of cases, the petition and OA, his lordship said that you prepare separate merit list. Preparing a separate merit list, not following the format that was prescribed for general recruitment, will not serve any purpose, and it is not the object of the rule, special category. Therefore, separate format should be there. Your lordship kindly the judgment last paragraph, page 252 of his lordship. Grid petition 6631. Sir, 42 para, the first line, given sutra, the second respondent shall prepare inter se merit list in respect of home guards being a special category. In view of the earlier decisions, his lordship not decided anything. Prepare separate merit list in the same format, but it is against the law laid down by the earlier division bench of this honorable court.
Come back again.
Preparing seniority list, separate merit list, applying same parameters that was applied for direct recruitment will not serve any purpose, and it is contrary to the directions of the earlier notifications. That is my submission.
That is what you have been harping on in the entire case.
Pardon?
That judgment only you are relying on.
Yes, well, we are relying, but this is not implemented. That's what we are lordship asking. This direction A 42A is in consequences to the orders passed in earlier OA and WP number 1142 of the batch. So this direction should be in consonance with the directions issued in the earlier. That's what my submission.
Even for treating them as a separate class, let us stand as in today. The rules, there is a rule for qualification.
The rule is kept in mind that the judgment is 97 is very much available.
What is 97?
The rule
87.
87 is only incorporating rule of reservation, horizontal reservation.
Physical parameters are also fixed. Kadande.
Sir?
Physical
97 it's
87.
already there in 97. Your lordship kindly similar page 97 GO 97.
They have been relaxed.
Your lordship GO 97 original GO.
Once those individuals qualify as for the parameters fixed, then they would be for inter-se seniority. Those posts which are designated for you will be meant for, provided you qualify in those parameters which they
Provided qualification is now the issue.
the issue in this.
How that qualification, how to be
Cheppandi, how you
how that now our question is if the same
answer should be, not the question.
my question posing my question to myself. Our question is for myself, the department. If the same 40-30 implemented, if the merit list is prepared among the separately from the home guards category, will not serve any purpose. That can be done as treating as direct recruitment vacancies concerned. If reserving post and treating as par with separate merit list, it is not an object.
Right, then how do you support, how do you expect the court to help you? On what principle can this court come by trying to
Our contention is it is covered by the judgment of the the judgment in WP 41142. Which is the subject matter of the OA 1142 page 2110. This is the basis decided in OA. If we lordship permits to treat the OA order, everything the contentions raised in present is already considered by the Honorable APT and is accepted by the Tribunal, High Court, this Honorable Court in the batch of petitions. All these contentions are raised, not challenging the notification rules, everything is discussed. Therefore, the issue to be considered by your
OA
lordship.
order.
What?
OA order.
OA order.
Where is
Page
it?
202 million. It starts from 200. Order from 2002. 202.
Right. You have, according to you, have qualified in the preliminary exam.
Preliminary exam, if party 30 applied, we are not qualified. Some of them qualified, 100 or 150. They were allowed not, even then they were not allowed for events. Then we filed this batch of petitions.
You are not even qualified in the preliminary examination.
100 120 qualified by securing the same marks. And more than 300 members were qualified in events. And mains, they were disqualified, applying the same marks. The prayer is squarely covers OA and the batch.
I think. Maybe the Incoros went on because they said that they are going to file a short counter in your case. Let them file a counter.
In my case also, Millard, I may be permitted to
No,
appear.
87, we don't have any quarrel, Millard. Therefore, we are not pleaded
don't
also.
have any quarrel. But, how do you implement when it is with reference to a post?
Subsequent to GO 97 rules only, those orders were come, Millard.
But this line of defense, was it addressed in other state of the rules framed and rules?
3D3 was interpreted, Millard. Special category. Yeah. And special class.
All that.
Item 98, Millard, this is.
You can examine whether government has got power to relax, because I don't see power of relaxation.
For that rule, they have a power to amend the notification.
No.
And para.
To amendment to notification cannot be contradicted.
For any relaxation or.
Don't go there. Examine the rules and see whether there is any provision under which government can relax the rules. Because there is no provision of relaxation of rules in the 99 rules.
99.
Stipendary cadet rules, there is no power of relaxation which is provided. Residuary power is not there. Relaxation rule ఉంటుంది కదండి, power to relax, that is not there in the stipendary cadet rules.
I will check up.
చూశాను నేను ఇందాక మీరు చదువుతున్నప్పుడు అదే చూస్తున్నాను. I did not find that. Whether in spite of it, government has inherent power to relax, or normally inherent power will be there with government because they are the recruiting agency. They are recruiting authority. Whether anything like that, you can just examine.
That In that parameters only, we are seeking indulgence of your lordship, my lord.
Indulgence also required to be within law, kadandi. I can't go, my sympathies can't prevail.
Government is having exclusive powers in our,
ఇప్పుడు నేను చెప్పాక మీరు చెప్పారు.
you-
You examine your own case.
I will check out.
Government has power to relax in spite of there being no specific provision in the rules to relax.
Right.
Inherent powers is not restricted to court. Inherent powers are there to the government also. So
I will check up.
I understood the case. No, I understood the case. I have understood the case.
Item 98, Millard, this is different, Millard.
Item 98. Delete post in usual course.
No.
It is different. It has to go before some other time. Just examine that. Meedi eppadiki pettamantaru? When do you want the next week is only
Events qualify and candidates.
first September for formal closure on that date. Which end? Heard learned Advocate General and Shri Sina Kumar in reply. Arguments are concluded. Post on 1/9